can be called upon by either of the parties. Now, one beautiful thing about calling of the witnesses is that, unlike in court, if a witness is called and the witness refuses to come, the court will summon the witness. Remember that I told you that the arbitral tribunal is an agent of undisclosed principal. The undisclosed principal is the court, and they have the same jurisdiction with the court. They are exercising the powers of the court. They are acting on behalf of the court. So if the arbitral tribunal summons a witness to appear before, anyway, the witnesses that can appear before arbitral tribunal are both competent and compellable witnesses. One thing is for a witness to be competent, another is for a witness to be compellable.
Okay.
His Excellency the Governor is a competent witness, but he's not a compellable witness. You cannot ask him to come and testify in court by virtue of his position. The Deputy Governor, the same. The President, the Vice President, they cannot. I don't know what I'm saying, but you can. But Senate President don't have such immunity as Speaker. That's why you see Saraki, they pull him, come and testify, come and do this in this case. They don't have that immunity clause. So they are competent, but they are not compellable.
Okay, I'm going to hold you at competent and compellable and non-compellable. Let me use your words. You're still on to Settle with Laughter on Salt Television, and somewhere along the line, I think I need to drink a little water. That's exactly what I mean when I want to tell you that I will need to go on a very short break. When we come back, competent and compellable, we'll take it up from there. Please stay with us.
The wheel of justice may grind slowly, but it will surely get to its destination of undiluted justice. But while you wait for justice, have you imagined how that long-drawn case can be settled out of court? Yes, we mean rebuilding a culture of amicable settlement of disputes through alternative dispute resolution. Settle with Laughter is a program tailored to educate, inform, sensitize, and promote access to justice through alternative dispute resolution anchored on mediation, consensus building, restorative justice, negotiation, and arbitration. Join an alternative dispute resolution expert, Barrister Ben Odoh, on Settle with Laughter on Soul TV, Abakaliki. Settle Dispute Television is an initiative of Negotiation Powerhouse Company Limited.
Okay, you're welcome back. It is still Settle with Laughter on Soul Television, and this is exactly where this business gets interactive, because this is exactly when we may want to have your comments, we may want to have your contributions, and you can get at us today with 0701 289 3728. The number will be displayed on your screen in a short while, when you can call us up and maybe make your contributions or ask questions as the case may be. You can also follow us on Facebook, just like our Facebook, and drop your comments on www.facebook.settlewithlaughter. On Instagram, it is Settle with Laughter. On YouTube, it is Settle with Laughter. On Twitter, it is Settle with Laughter. Just with a little difference that laughter on our Twitter handle is LAFTA, not the conventional laughter of LAUGHTER. All right, we can work together. You can also send your SMS to 0803-509-7383. But for us to talk one-on-one right now on the program as it progresses, you can just call us up on the number you have on your screen, 0701-289-3728. All right, compellable and competent and compellable. That's where we start. And I'm very interested in that word. I want to hear it over and over again. Please, can you tell us more of what you mean by
said, witnesses you are you are summoned to testify must be competent and compellable witnesses. Okay. One is for them to be competent. Now, someone who is mad is not a competent witness. An insane person is not competent and is not compellable.
It's not compellable, yes.
Now, someone who has loss of memory is not competent and compellable. Suffering from epilepsy, someone suffering from epilepsy is not competent and is not compellable.
But why?
And then except during the lucid moment.
Good, because I know that it doesn't always happen.
Yes, I said except at that time of that crisis, except during the lucid moment. Now, they are not competent and they are not compellable. But then a witness can also be competent, but they may not be compellable. And I gave you an example that by immunity clause, by immunity provision. Now, some people are competent, but they are not compellable. And I told you, His Excellency the Governor and the Deputy Governor, the President and the Vice President, and then diplomats, ambassadors, they are competent, but they are not compellable within the period they are in the position. Within the period they are in the position. So these people, so now if a party, if a witness is summoned, if a witness is called to come and testify in arbitral tribunal and say, oh, this is not court, I cannot come. The arbitral tribunal under section 23 have been given powers by the court to summon them. Now, how is it done? The arbitral tribunal, are you know what I'm saying now? Yeah. Applies to court, and the court will now issue them writ of subpoena. If it is for them to come and tender document, they will now be given a writ called writ of subpoena ad testificandum. Are you know what I'm saying? To come and submit documents to come and testify. Now, if it is for people that are with documents, the people that have documents that are in custody of a document that will be relevant to either of the parties in the matter he is either claiming or he is either defending, then what the person would do is to notify the arbitral tribunal. The tribunal will do what? Will write to the court to seek for the leave of the court, and the court will now grant writ of subpoena ad duce tecum for the person to come and produce the document in his custody. If it is for for the person just to come and testify only, it is writ of subpoena ad testificandum. Now, assuming if it is for someone who is already in prison custody, is in prison, and then but you need him to come and testify in court. Now, what the tribunal will do, the party that is calling the witness will apply to the tribunal. The tribunal will now write to the judge, apply to the judge, seek the leave of the judge and the court. And the court will now grant another writ of summon, another writ of subpoena. But that one is subpoena habeas corpus ad testificandum. It will be issued to the prison officials to produce such inmate in their custody to come before the arbitral tribunal and testify. Now, during hearing, parties can say, oh, this matter is already dilly-dallying, is being protracted. Why don't us agree to resolve our matter and then tell the arbitral tribunal to adopt our decision as theirs, or we call out of court settlement. The parties can on their own resolve the matter and then take whatever thing they have agreed and give to the arbitral tribunal to adopt as their own decision. Now, it is permitted under section 25. We'll call it, if the arbitral tribunal accepts, that ends that proceeding, and they will now give a judgment that is called consent award based on the agreement of the parties. Now, during hearing too, once the arbitral, like I said, the parties may, during hearing, the arbitral tribunal may not have sufficient knowledge of the subject matter. Are you know what I'm saying?
Yes.
May not have sufficient knowledge of the subject matter. Now, if the arbitral tribunal don't have sufficient knowledge of the subject matter, now the parties can, if they have so agreed that the arbitral tribunal should go on, appoint experts to assist the tribunal
No, wait. Sorry. What would be the need? This is about the last stage. The hearing stage is about the last stage. We've gone through the preliminary stage, the preliminary meeting, the pre-hearing. If at this particular stage of the hearing, they still don't have enough knowledge, don't you? I'm of the view that what's the need keeping them, other than going to now invite experts to come in? Why not just drop this?
Let us say parties can agree. The expert can come either during preliminary meeting or during pre-hearing meeting or during hearing. Or they can say, okay, hearing is the crux of the matter. Now the experts can just come during the hearing to see how the hearing is going on and give expert opinion. And
the expert, the disputants are in charge of
I give you an example.
Okay.
Now, assuming I'm a lawyer and I've been appointed, let's just use this Dana Airline plane crash, okay, which is ongoing now. So assuming I am appointed as an arbitrator, I don't have knowledge of aviation. Are you know what I'm saying?
Yes.
So as a lawyer, what do I need to do? The parties can appoint experts in aviation to guide me relating to the ones I don't know. While I will be using my legal knowledge over it, they will be telling me about
the technical
aspect of the aviation. And then we'll come together and work so parties can agree on that.
Okay, I get it.
Are you getting what I'm saying now? Now, during hearing. Now, there's something I need to point out here. That during hearing, the arbitral tribunal owe a duty of disclosure to the parties. Now, this disclosure can come during hearing or before hearing.
Okay.
This is provided under Section 8, subsection 3A and B. Now, and if the arbitrator or arbitral tribunal fails to disclose this, I think I'm saying, if he fails, it can be a grant to challenging the award. Now, what are these duty of disclosure? Under Section 8, subsection 1, the arbitral tribunal, if there is anything that he knows that may be a hindrance or may be a hiccup to the arbitration proceeding, he's expected to disclose that. Now, but if he fails to do that, now it will be a grant challenging that tribunal. Now, I give you an example, sir. Now, I should go on?
Go ahead.
Okay. Now, under Section 8, subsection 3A, where exist circumstances giving rise to justifiable doubt as to the arbitrator's impartiality, neutrality, and independence, that shall be ground for challenging the jurisdiction of the arbitral tribunal to go on with the hearing. I don't know whether you're getting what I'm saying now. Remember, I said Section 8, subsection Section 3A provide where exist circumstances that is giving rise to justifiable doubt as to the arbitrator's neutrality, independence, and impartiality.
Hello? Hello? Okay, please, you can move away from your TV set when you do want to make a call, because if you don't, we'll be getting holdbacks like the caller we just got right now. And the number still remains 0701-289-3728. And time really ticking so fast that we really actually need to, I would prefer a situation where we're able to handle everything that has to do with the flow of arbitration, so that maybe we'll talk about awards by the next time we'll meet here, because I heard you say something about awards. So I want to understand, even arbitration, we're having something different from the natural or the conventional award we have in the dictionary. But that's going to be when we are done talking about hearing as it concerns the flow of arbitration. Please go ahead.
So I said, if there exist circumstances giving rise to justifiable doubt as to the arbitrator's neutrality, independence, and impartiality, it shall be a ground to challenge the jurisdiction of the arbitral tribunal during hearing. Now, what are these justifiable circumstances giving rise to justifiable doubt? Party A appointed an arbitrator. Party B appointed an arbitrator, and the two arbitrators are to appoint the third person to chair the proceedings. Are you know what I'm saying now? And then the person who is to chair the proceeding, assuming the person who is to chair the proceeding, is a brother to the arbitrator appointed by party A and the party B too. I don't know whether you agree what I'm saying now. Now it is a duty of the arbitral tribunal to say, look, oh, I am a brother to so party. Do you permit I should go ahead, or should I terminate the mandate given to me? If at the end the party say, okay, we know you are disciplined and principled, go ahead and hear the matter. Then the position stands. But if they say, look.
Excuse me. Hello. Yeah, good morning. Please, what is your name? Okay, we lost that.
So, but if they say, look, you cannot be a brother to one of the parties in dispute, and you are presiding as a tribunal. Now, what will you do? You will now terminate the mandate given to you by the parties and enable them appoint another arbitral tribunal. That is circumstances giving rise to justifiable doubt. There is doubt. There's justifiable doubt as to their impartiality and neutrality. The second ground is where the arbitral tribunal lacks the requisite knowledge expected of the tribunal under Section 8 or Section 3B. Now, if you tell them, like I said here, I am a lawyer, I don't have any knowledge of aviation, what do you think? And they say, we know, but we're going to invite an expert to assist you. Good and fine. The proceeding will go on. But if the person says, we thought you're also an aviation lawyer. I say, no, I am not. I will now terminate the mandate given to me to enable them appoint either an aviation lawyer or an expert to go on with the matter. Then thereafter, once the claimant is able to conclude his claim, calling the witnesses, adducing the necessary document, and concluding his case, then the respondent or the defendant opens his own case, calls his own witnesses, his own witnesses is being examined by the claimant, and then he will now close his case, enable the arbitral tribunal go on with the award.
Let me see who is here, and that may be the last we have today. Hello? Hello? Okay, we simply cannot get through to this, and my revered audience, I want to let you know that time is really not longer on our side and on Settle with Laughter on South Television today. And you may need to know that we have this business. A repeat broadcast of what we have today will be on by 10:30 on Tuesday, and I do hope you'll be our guest until then. And we'll be meeting again on Saturday. But until Saturday or before Saturday, we can still interact. If there are issues you want us to talk about, that's the real essence of this program. We can discuss that off camera. And that's when we may expect to send your SMS to 0803-509-7383. Okay, and you can like our Facebook page and drop your comment or make your contributions on www.settlewithlaughter. On Instagram, it is Settle with Laughter. On YouTube, it is Settle with Laughter. On Twitter, it is also Settle with Laughter. But this time it is LAFTA. That's laughter for Twitter. Please keep being good and keep staying out of trouble and keep making the world a better place by being a very peaceful person. My guest has always been the PA Technical to the Deputy Governor of Ebonyi State, Barrister Ben Odoh Uruchi. Please, we appreciate you all the time.
Thank you.
Always making our time to come here.
Thank you, sir.
My name is Chika Igwe, and on behalf of the crew that made this happen, I want to say, be the best of what you are. Be a good Nigerian, and let's make this world better. Until we meet again, stay blessed.